Welcome to Law Talk Live. I'm your host, Gina Goosmann, CEO, founding and practicing attorney at Goosmann Law Firm. At Goosmann, we work alongside business owners, leaders, and innovators who are building something meaningful and want to protect it, grow it, and lead it with clarity. This series is all about bringing you real-world strategies, timely insight, and perspectives from professionals who are in it every day. You are now tuned in to Law Talk Live. Good afternoon, everyone, and welcome to Law Talk Live. I'm your host, Gina Goosmann, founder, CEO, and practicing attorney at the Goosmann Law Firm. And today I'm joined with two of my law partners, Steve Henricks and William Hale. And we're going to be talking about some of the lessons learned from one of Nebraska's largest construction disputes and really how that can help gain knowledge for contractors, developers, construction professionals, owners, and what you might be able to take away from some of those high stakes litigation lessons that we have become aware of. And really, I want to help frame up today's discussion as something practical for you, things that you can think about as you're doing deals and doing projects, and how you can think about contracts, risk allocation, insurance, documentation, who's on your team, key employees, and leadership decisions that could shape the outcome of a future dispute and really impact your company and your business well before you step into our courtroom. As a reminder, this is just a general discussion. We're not giving away any particular legal advice. We're not going to talk in specifics. It's really just some of the lessons that we've learned through the course of our careers and from handling particular big cases. So with that in mind, I would love to have my partners introduce themselves. And I'm going to kick it over to you first, Steve, if you want to introduce yourself to our listeners.
Hi, Gina, and thank you. My name is Steve Henricks, and I am the Practice Area Group Chair at Goosmann. I've been doing that for the last approximately year and a half. During that time, I would say that probably 80% of my litigation time is spent with exactly the topic today, dealing with contract disputes in the construction world. It's 80%, and it happens all the time, and we represent parties at all levels, from the owners to the general contractors to the subcontractors.
Awesome. And Steve, before joining us, I always think it's interesting to share, he was in the military and actually served as a judge and has had over 1,000 trials that he's been a part of. So lots of experience there to pull upon, and certainly a zealous advocate for clients today.
Thank you, Gina.
Will, how about you introduce yourself to our listeners?
Yeah, absolutely. So I am the managing partner of our Sioux City office here at the Goosmann Law Firm. I've been in practice for about 10 years now and handle a wide range of disputes, including quite a few construction disputes as well. I like to tell everybody that I'm a litigator, so I sue people for money, and that's what I enjoy.
And Will, you're licensed in 3 states, I believe.
That's right. Nebraska, Iowa, and South Dakota, both state and federal court for all 3 of those states.
Awesome. And I myself have been involved in a lot of large construction disputes, including the one that we referenced in the marketing of this episode here today, which, was hundreds of millions of dollars in dispute and took several years to resolve. And I also serve as a AAA arbitrator these days, and I just got added to the construction law panel for construction disputes that I can sit and arbitrate. So with that background, let's go ahead and jump right in. And really, why is this topic important for construction leaders now? What are your thoughts on that?
I think it's important personally because there's so much that can go wrong, so much that people don't think about. A lot of times the contractors that I've worked with think that a handshake is good enough, which is always good enough until it's not. And you need to be able to be prepared about that to have everything in place before it goes bad.
Steve, when we're looking at major construction disputes, how much does the contract really shape the outcome, and how much does that contract really matter?
Gina, I cannot overemphasize how important the contract is. By way of analogy, it would be like playing Monopoly without reading the rules. You have to sit down and when you play that game, look over the rules, understand what happens when you pass go, understand what happens when you land on a space. A contract, especially in construction world, does exactly the same thing. The terms in the contract can set up exactly what's going to happen later on if there's a dispute between the parties. And the litigants, and especially our client, they must know what those terms are. It doesn't really do our clients much good if they're just learning about these very important terms when things are going south. And to kind of piggyback on what Will said, we don't live in a perfect world. So you have to plan, just not hope that things don't go bad, but you have to plan in case things sour between the parties to a contract, what the contract is going to call for. Some of the very common things that come up in a contract when things are going south is to look at something called a pay if or pay when clause. That's very important because based on the wording of the contract, will determine if and when the general contractor has to pay the subs. Will they have to pay based on the contingency of the owner paying them, or will they have to pay outright regardless if the owner pays? So that's a very important clause that we need to know the wording of, and also what the state law is concerning such topics. Also, if there's a dispute between the parties, does it require arbitration or not? We need to look at that. And another common clause that you need to know the answer to is if it sets where the venue is going to be, if there's a dispute between the parties at Nebraska or some other state. And also if it says what law is going to apply. Will Nebraska law or some other state apply? These are just 3 examples, but these are very important clauses, and they set the parameters for how the parties will resolve their disputes.
Let's talk for a minute about the legal entity that signs the contract and how much that matters. Will, thoughts on that?
You need to make sure that you got the right entity involved right from the get-go. Otherwise, you might get down a road and be trying to go after them or trying to get money out of them, and you're barking up the wrong tree. If you've signed a contract with ABC LLC, but really it's been DEF that's been paying you and has the money, if you have to go after them later, if you try to sue the one that's been paying you, but they're not the one on the contract, you're not going to get very far. And if the person you've contracted with doesn't have the money, even if you sue the right person, there may not be much to get. So it's important to know who you're actually dealing with, what assets they may have if it does come to that, and who's actually the one guaranteeing that you're going to get paid at the end of the day.
Absolutely. And a lot of companies have multiple entities and subsidiaries and sister companies and all kinds of stuff. So I think in DBAs, those come into play, and it can be really confusing. So if somebody consults with the lawyer to figure out who's the right party, that's always a good thing. Now, what about pricing terms and damages provisions regarding what happens if there's an issue such as liquidated damages? Steve, thoughts on that?
Well, this gets back to what I was just talking about, Gina, and that is the terms of the contract are so important. You just can't overemphasize that. So first off, let's just circle back. When you're entering the contract, as Will talked about, please don't just make it a handshake deal if you can. Please have your attorney or your law firm look it over so you understand the risk that you're getting into. Let's say, for example, we have a guaranteed maximum price contract. Now, that's going to amplify the risks that's going to come out there because it sets a ceiling on the cost that the general contractor can expend. Now, if you go over that as the general contractor, you're going to have to eat all that cost. You're not going to get reimbursed for it. However, it also incentivizes savings because if you come in less than what the guaranteed price is going to be, then you and usually the owner will split that savings. So it gives you a reward as a general contractor. But that's something you need to be aware of. Additionally, you're going to look at things that touch on another topic we'll talk about later, which is consequential damages. But for example, does the contract clearly spell out if you're going to have just cost to complete damages, or if you're going to go into lost profits? Lost profits, you need to be aware of that because suddenly that can open the floodgates to damages that perhaps you as a general contractor do not want to be exposed to. And so you want to early on try to negotiate out of that. Those are just 2 examples. Hopefully we don't have to get into that and we can resolve those issues before we get to the dispute between the parties, but you need to be aware of how that deals. Another important clause that's out there is about liquidated damages. Oftentimes the owner and general contractor with the subs will want to put in case there's a breach, we don't even have to get into what damages are. You're going to owe X amount per day. That's something also that lawyers need to pay a lot of time drafting, paying attention to, and advising the client on, because you want to make sure that the liquidated damages clause doesn't cross the line into a punitive or penalty phase, because if you do that, you run the risk of it not being enforceable.
Time is money, as they say.
Yes, ma'am.
Okay, let's talk about change orders. Change orders are so common in construction and in different projects. So how do they work, and how do they really become litigation evidence as well?
Well, Gina, first off, let's start with the maxim that you hope that the parties to a contract are abiding by, and that is no work without written approval. And so oftentimes you'll get into a contract, and again, the world is not perfect and things will have to change. So the name before it follows what it does. There needs to be a change to a contract, and either the general contractor or the sub takes it to the next level up, or sometimes the owner will take it to the general contractor and say, things aren't working out exactly like we thought when we got into this contract. We need to change it in some form or fashion. That's what a change order is. And the point and the takeaway is, don't just do this, again, to Will's point, on a handshake. Make sure it's in writing and make sure it's been approved. Now, also, these things can, it's just not that simple, because sometimes the parties to a contract will start to play games and perhaps are not acting in good faith. So, for example, one way this plays out is if someone puts a very low bid in, a company puts a very low bid in, and they're awarded the contract, but their plan all along was, we'll get the lowest bid in, and then we'll submit change order after change order after change order, upping the price to what was a more realistic price to begin with. So if that's happening, usually there's going to be some type of discovery, paper trail, email trail to that. And then also looking at it from the other way is cornering. Sometimes a owner will downplay what the contract is going to entail, and then as soon as they have someone locked into a contract, they will corner that person by giving them a bunch of change orders requiring much more expense and time to be laid out. And the general contractor then finds themselves in the unenviable position of having to make a choice between going along with the change orders or facing penalties under the contract for not completing it on time. So you just have to be aware that those things can play out that way. And if you feel that's going on, if your spidey sense is going off, contact your attorney, hopefully us, right away, and we can start dealing with the problem at that time.
Well, let's talk a little bit about indemnity and what people misunderstand about indemnity, and then the other key provisions about duty to defend. Can you talk about those for us?
Yeah, absolutely. So oftentimes in a contract, you find clauses that will say that you must indemnify another person, or you have a duty to defend them. And what that means is if you have agreed to indemnify your subcontractor, for example, then if the project owner, the property owner has an issue that came up, if they're looking to sue somebody, even if they sued your subcontractor for bad work that your subcontractor did, if you have that indemnity clause in there, the general contractor, may be on the hook for whatever damages, whatever result comes from that lawsuit. You may have to pay those. Or if you have a duty to defend, which often goes along with that, you may have to be the one as the general contractor who's paying for the attorney for your subcontractor to defend against the accusations that their portion of the work was incorrect or was not up to the standards. And so those, you have to be very careful and understand exactly what those mean, because it could put you on the hook for bad work that someone else does. Oftentimes it can cut both ways. So sometimes it may be something that you don't want in the contract because you don't want to be held responsible for the bad work of someone else. But maybe if you are the subcontractor, maybe you do want that in the contract to try to get the general contractor to be responsible for any issues that you may have. So depending on what your role is on the project, you may have a different view as to whether those are good or not. And the point to address that is before the project starts, before people sign the contract. You need to know what it's saying, and you need to determine whether it's something you can live with and whether it is appropriate for what you want to accomplish.
Steve, let's talk a little bit about the insurance realities and how insurance plays into these disputes and really impacts cases.
Well, Gina, I think first off, clients will come in and they're like, hey, there's a dispute that's happening. Is my insurance going to cover this? And so we'll look at the contract. We'll usually advise a client they need to submit a claim to their insurance carrier. And then the all-important, will the insurance company write back and say, your claim is covered, you're going to provide you a defense, we're going to provide you attorneys to help represent you in this, or, and you need to make sure before I move on, also that that's timely submitted. So don't sit on something if you think a claim is out there. You need to get it to your insurance carrier pretty much as soon as you can. And Will, do you have anything else to add to that topic?
Yeah, absolutely. You need to be careful right from the beginning, make sure you've got enough coverage, but also that you understand what is covered by your insurance, because oftentimes you might think that you've got insurance in place and you may think that it's going to provide you coverage, but the particular claim that is brought up might not be covered. If you've got those indemnity clauses in there, like we were talking about earlier, is your insurance going to cover you if you have to indemnify a subcontractor? And maybe it won't. So you could get in a sticky position there. Another part to make sure you understand with your insurance coverage is whether that coverage erodes as it goes on. You may have $1 million coverage with your insurance, and then you get into a big lawsuit, and as you are fighting that lawsuit, you think that you have this $1 million bucket there to be able to pay whatever you end up maybe owing to the other side. However, if your coverage erodes like that, what it means is as your insurance pays the attorney, you no longer have $1 million in that bucket. As the attorney gets paid, that amount goes down and down, and depending how big or how hard the fight is, it could get down lower than what you need to satisfy the judgment, and you might be on the hook for that. So you got to be careful, and you got to understand what your insurance policy is and what it covers.
I think a few things I always encounter in this world too is failure to get paid is not an insurable thing. And so that's usually how these disputes start, is somebody isn't getting paid. And when you want to get paid and you have to sue somebody to get paid, that's not something that your insurance kicks in for. And that can really start, costing people money, and they think they have insurance coverage for things, but it's really a business dispute and a breach of contract. And a lot of times those aren't covered in that regard. And then on the other hand, if you're the owner and you're suing because you want to get a project complete, or you think the project was done poorly, the owner often doesn't have insurance coverage either. And then on the other hand, if there was poor performance of the work or work product issues, the defense may have insurance coverage. So you end up with a unique dynamic where one party in a case has insurance coverage and the other does not. And that tends to impact how much people really want to fight in a dispute. The party that's getting their legal bills paid by an insurance company, they tend to want to drag it out and fight longer. And the company that, they're paying it themselves out of pocket, I think they usually want this done as efficiently as possible. And that creates a tension in the cases.
It absolutely does.
Moving along, let's talk a little bit about arbitration versus in-court actions and how that really comes to play, and what kicks the case into arbitration versus when does it stay in court.
Yeah, I can jump in there. So arbitration usually happens if there's a clause in the contract beforehand, and maybe somebody was using a form and they didn't even realize it's in there, but the contract may say that any disputes between the party has to go through arbitration. A lot of people don't realize what the difference between arbitration and going to court is. They kind of consider it the same, and in some aspects it works similarly. However, arbitration ends up being a lot quicker of a process usually, and it's not always cheaper. It ends up being more private, and it's not out there as easily found in the public domain. which can be good or bad depending on which side you are on that and the circumstances of the case. And you just don't have the same, like you don't have the access to a jury in an arbitration. If depending on what your claim is, maybe you want that jury, maybe you want those normal individuals that are going to sympathize with you, and you just don't get that in arbitration.
That's right. Well, so it's either a contract clause that requires it, or both parties have to agree to arbitrate. Otherwise, you're going to be in court at the end of the day. So good summary there. Steve, how about jurisdiction and venue and those clauses in contracts? How do those impact a case? Did I lose Steve?
I think he might be muted.
Oh, here
Yes,
you come.
Thank
Steve,
you, Gina.
yeah, talk to me about jurisdiction and venue and how those impact a case and contract clauses involving jurisdiction and venue.
Absolutely. Again, these contract clauses that we're going over and mentioning are absolutely vital for setting the rules of the case, how the case is likely going to turn out. So let me just give you a quick example. In Nebraska, it's very hard and almost impossible in a contract dispute for the court to award attorney's fees. However, if you go to other states, for example, Illinois, I believe it's routine sometimes in those cases for attorney fees to be awarded as part of a case judgment by a judge or jury. And so when you pick up the contract and it says, then you pick Nebraska, you have an idea of what's going to happen with claims for attorney's fees. Probably not going to happen. When you go into Illinois, however, if the contract says that the venue selection and the laws of Illinois are going to apply, and we're going to try this case in Chicago, now you have to be aware that you could be, if you don't prevail, just like the other side, could be on the hook for substantial legal fees if the case goes all the way to the trial. So that is just an important thing that the parties have to be aware of if they're deciding to move into litigation or not.
You bet. And I think for Midwest-based companies, a lot of times we like to have our cases heard in the Midwest. And if we see a New York venue or a California venue, that can really up the ante in those disputes.
Yes. So typically our advice is let's keep it here in Nebraska. But occasionally we'll get a case that we didn't advise on, and the contract will put it exactly in one of those two forms, which can really open the door to what a client could recoup or what they're going to be exposed to.
Absolutely. And every law is so different. I know practicing in the 3 states, Iowa, Nebraska, and South Dakota, that's the first thing I have to figure out is, okay, which state am I in? Because they all have different laws and big impact depending on choice of law provisions there. Hey, well, let's jump over and talk a little bit about witnesses in a dispute and who often becomes a witness in a case and how that matters and why it matters.
Absolutely, especially when it's going before the decider of fact, either the arbitrator or especially if it's a jury. The credibility of the witnesses that you present or that you're able to call from the other side really can make or break your case. Is that person going to be believable? And the type of people that usually end up being witnesses are the owners, the project managers, even some of the day-to-day people that are involved in the work itself, that are doing the work that is being called into question, from all levels, from the actual people hammering the nails sometimes, all the way up to the person sitting in the back office that negotiated the contract originally. Any of those can be a witness, including past employees. If you have an employee who is working on the job and then you end up firing them for whatever reason, even a reason completely unrelated to the project, they might still be a witness. And so you got to think through, what type of witness are they going to be? Are they holding a grudge and are they going to say things just to get back at you? Or even though they may not like you, they're still going to tell the truth. And is that work in your favor or does that work against you? So it can be anybody at all that has touched the project in any way that could end up being a witness.
I often work with CEOs and presidents at the top of that chain as far as how they prepare and how they present themselves when it comes time for their depositions and their testimony. Because I think if they don't portray the company in a positive light, that really hurts the case for their business. And it's almost required that the jury or the judge like them and find them credible, because if not, you might as well just sink the case right then and there. But it always matters too what the other witnesses have to say. So thinking through, how do your employees respond and react, and how are you training and developing those people, and who are you hiring, and how are you going about your HR practices? They can definitely come back and shed either a positive light or cast a negative one on the business. Let's move around and talk more about the documents and emails and text messages. And these days we even have AI in the mix. Thoughts on that and how that comes to impact a case, and how we go about gathering those pieces of evidence when we're preparing a dispute?
Gina, I'll start off on that topic. As you mentioned, I was in the Army. I was in there for 32 years, and we had a rule that I think lends itself well to the disputes we're talking about today. And the rule is, will your email pass the Washington Post test? And what that means is, are you writing something that if the Washington Post got hold of it, you're okay with that being published somewhere in the newspaper? If the answer is yes, then go ahead and send that email. If the answer is no, do not send that email. And I think the same thing applies here with a slight twist, and that is what you're writing going to be okay to be seen in court and to be seen publicly? If the answer to that is yes, go ahead and send that email. If the answer is no, get up, walk around the block, count to 10, and then think about if you really want to send that email. If it feels too good to send that email, then don't send it, because you're probably doing something, even though it's scratching that itch of you're upset about something. You don't want to have to eat your words 3-4 years later because that email got sent. So that's how they become evidence. You write something that perhaps was intemperate at the time. It has to be disclosed in discovery, and suddenly the other side has Exhibit A to be shown to the judge and jury.
And just to add on to that briefly there, even things that you think are more private could come out in the litigation. We've had cases Gina and I have worked on where they very specifically asked for stuff from the Signal app, and we've had to produce it. And so even though you expect that could be a more private type of communication, it is not, and it can come out in discovery. In the industry, we've also seen lawyers starting to ask for what prompts people are putting into AI. So if you're on your computer and you're asking AI about things, that is not necessarily going to remain secret either. So you have to be careful of all that. And as Steve was saying, think about, is this something that you would mind if it showed up in court, or is that going to look bad for you?
Now, Steve, most cases actually settle before the trial. And what kinds of tools do we have to help clients settle their case?
Well, one, us, Gina. You get the best attorneys you can here at Goosmann. And oftentimes when we sit down with clients, they will tell us the business decision is, we don't want this litigation to continue forward. Please go out and get it settled. Once we're given that charge, we can go to mediation. We can develop the facts in such a way that the other side realizes it's more advantageous for them to settle. And those are the two primary ways. But overall, you're simply trying to now convince the other side that it's the business decision they also need to make is get some predictability in the case, and let's settle this on terms that both parties can at least live with.
You bet. And a lot of times it can kind of bump right up until the trial date too. So having a good schedule can help with the case too. I'd like to just touch upon kind of strategy a little bit. I'm a strategic competitor, and I think that's my favorite part of a case is coming up with themes and really how you can navigate the tools that lawyers have in the legal system that we have in America in order to resolve your disputes and really what wins a case. And ultimately, a lot of times we like to test out those theories and see how a jury might react to potential witness testimony. And we've been fortunate enough to also work with focus groups and do mock trials in order to help clients see how this case may resolve. And that too can then help you resolve a case. If you go in and you get a mock jury award and it's much higher or much less than you're anticipating, that might make people think a little bit differently about their case. We actually have a lot more science that we're able to bring to litigation and to trial strategy than we ever have before. And I think a lot of our technology tools are helping us as we evaluate cases and help clients navigate these different disputes. But with that, I think I'd love to kick it back to each of you as we're starting to wrap this up. Will or Steve, one thought you'd like to leave with the construction leaders that may be listening on something that they should take away from handling disputes and all your years of handling them?
I'll start there. I think probably the takeaway that I have is you need to think about a potential dispute before you even start the project. And that can come from making sure you've got the right contracts in place and that you do take the appropriate steps along the way with the appropriate change orders, with watching what you do put in writing and things like that. So that way you're set up for the best chance of success. The better your contract is, the less disputes you may have. And if it comes to one, the better position you'll be in.
Great points, Will. Steve, how about you?
Yeah, and just to carry that thought, hope for the best, but plan for the worst. And so make sure the contract and the terms we've talked about, you're familiar with them and that you've had your lawyer look them over and you discuss them together. And then if things do go south, get your lawyer, hopefully here at Goosmann, back involved as soon as possible so we can give you the best chance of success in resolving whatever this business dispute is on the best terms favorable to you.
We've got a few questions in the comments on LinkedIn, and so I'd love to pick up some of those. Sarah asked, if your insurance company decides to represent you in a claim, does that mean all of your interests are covered? Is there a case when you might need additional counsel? Thoughts about that?
Yeah, absolutely. Your insurance may not want to settle a claim when you maybe do. Perhaps your insurance carrier, and if they're the ones paying your legal fees, they may want to push it through, or the opposite. Maybe they want to try to settle it and you don't. There could be some implications where you don't want to make it look like you've admitted to something through a settlement and want to carry it on, but your insurance company doesn't want to. So there can easily be some conflicting interests there. And in those cases, it's sometimes good to pay for your own attorney in addition to the one being paid for by your insurance carrier to help make sure that your interests are actually being heard and are being focused on as well.
And sometimes your insurance company wants to hire a certain counsel, but you want your own lawyer and you might need to pay the fee split. If insurance defense counsel is, $350 an hour and your attorney costs more than that, you can pay the difference and keep your own counsel on the case. So lots of things to think through when insurance is involved for sure. Good thoughts, Will. The next one here, we've got, when a construction dispute begins moving from a project issue to a business risk, what should a company's legal team be looking at first? Oh, that's from Abby. When it becomes a business risk. A lot of times we get involved in some bet the company cases, don't we? And really, what do we need to be thinking about when that's the case? Any particular thoughts come to mind for either of you on that?
Well, Gina, I'll take this one. And this just goes back to what we've been talking about from the beginning of this presentation, which is the first thing to think about when it moves from a project issue to a business risk is, what does the contract say? So when it's moving to that business risk, get your attorney. That's the trigger to get your law firm and your attorney involved. Dust off that contract. Hopefully there's not too much on it. Look it over and then see, okay, this is what's going to happen. These are the rules of the game of if this moves from risk to litigation. And then once you understand that, you can come up with your business plan, how you're going to address it.
Yeah, and I think along those lines too, there's other things to think about when there's a major dispute, such as the public relations, PR within the industry, maybe even internally with your own team. And there's beyond just exactly what happens in the case, how it can impact how a lawsuit can essentially impact the business as a whole. The next one, it's specifically for Steve from a LinkedIn user. In construction litigation cases, do you approach it with a case theme in mind? If so, how do you decide what sort of theme will resonate most with the judge, jury, arbitrator, or mediator?
Okay, litigation 101 is pick your theme for the jury and for the judge. So regardless if your case is criminal, if it's personal injury, or a construction dispute, you absolutely have to pick your theme for the case or themes for the case. And then everything else that happens in the case as we're moving towards litigation, or perhaps we're already in litigation, either flows from those themes or slightly changes them as you're moving forward. But the things that I look for as we're deciding what the theme is going to be are those things that's going to resonate with the jury and judge. So it's not going to be dry contract language. It's going to be relating to what the jury will understand and what will drive them to make a decision in our favor. So that's what I'm looking for. So it's not the contract, blah, 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 requires this. It's the other side did something and they did that to get this advantage, which was unfair, and they're trying to take advantage of the situation. Those are examples of some themes that can present themselves in these cases. And Gina, you're good.
Thank you for that. The next question comes from Chris. When a construction project involves multiple entities, subcontractors, lenders, and owners, what business side risks should attorneys be watching for before the contract is signed? I'll take that for a minute. I think making sure that you're doing business with the right people does matter. So just because somebody's low bid doesn't mean that they're the best selection for you, or even when it comes to your lender and the interest rate that they're going to choose. Doing business with people that you trust really does make an impact in the ultimate outcome of a project. And making sure people are well capitalized and that they have the wherewithal to take on that project. And if you have, a good track record with people that you've worked with before, I think having strong relationships certainly makes an impact. So great question, Chris. The next one is from Sarah. And Will, this is for you. If a client is using an AI program like ChatGPT to think through the case, is the information the client enters into the chat discoverable?
It's a great question, and the very lawyerly answer to that is it depends. This is a new and quickly changing area of the law right now. We're waiting on some direction from some of the courts across the country to see exactly how it comes out. But the indications we've got so far is that it could be. Some of it may be based on what security settings and various different factors. But at this point, I think it is still wise to be very careful and very cautious with what you put in there. It's better to err on the side that it could be discoverable, and as opposed to erring the other way and hoping that it's not discoverable. So my advice is to assume that it could come out later. And if you're looking for advice on what to do, then it's best to talk to your actual attorney on that. They'll be able to evaluate the risks and actually give you better advice than AI can, and still keep that privilege intact as well.
All right, we've got one more question. And I think this comes from Jamie. In a high-stakes construction dispute, what early litigation strategy decisions tend to have the biggest impact on leverage, settlement posture, and overall case outcome? Early strategy decisions. Thoughts on that, either of you?
I think one of the early decisions is what Steve was talking about early on a minute ago with theme, especially depending on who your audience is. If you can get the right theme early on and then build your case around that, it can make it more relatable and more easily understood. If it goes before a jury, you're not going to have a jury full of construction people. You may have some on there, but it's not going to be everybody. And so you need to be able to have that as understandable as possible. And how can you simplify it in the terms they understand?
One last comment on early strategies, I think, too, is when to sue and who sues first. That's always kind of a biggie in these cases. Whoever sues first becomes the plaintiff. And some lawyers think that that gives them an advantage because they feel like the wronged party since they're the plaintiff. You can always counterclaim and countersue, and that's often common as well. But when to sue and when to pull that trigger is usually an early case strategy decision. Thank you so much for all the questions. And I wanted to thank, in particular, Steve and Will for coming on today and talking through construction disputes and some of the things that we often encounter in these cases and some of our lessons that we've learned over the years, and breaking it down for our listeners in construction and in business, and giving some pointers that leaders can actually use and some things that should be thought about early in the case, especially as they're taking on big projects and thinking through serious issues that have major impact on their business and on their livelihood. So appreciate you so much for joining us as well on Law Talk Live here today. We hope that you've had a good time listening to this conversation, and I want to encourage you as well to tune into our next Law Talk Live, which is scheduled for July 27th at noon as well. And we're going to have Mark Haysbrook on for Law Talk Live on July 27th. Thank you so much for listening today. Have a great afternoon.
Take care.
At Goosmann Law Firm, we believe the right conversations at the right time can change the trajectory of a business, a decision, or even a legacy. You can connect with us here on LinkedIn, follow along for future sessions, or visit GoosmannLaw.com for more information and additional resources. Thanks for joining us today, and we'll see you next time.